Thank you, Judge. Now, we're going to talk about each of those rule changes in order, but as we do that, I'm going to put the new rule amendments up so to make sure that everyone understands which rules we're talking about. We're going to start with the scope of discovery 26B1, which has been amended, or will be as of December 1st, to include a proportionality test. So the proportionality as part of the scope of discovery, the new rule is going to say that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. And there is a proportionality test. So proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefits. Information within the scope of the discovery need not be admissible in evidence to be discoverable. So that is what the rule will say as of December 1st. Important to note what has been omitted from the rule. The well-known phrase and what has been misinterpreted as the actual scope of discovery for decades, relevant information need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence, gone from the rule. Similarly, the phrase that for good cause the court may order discovery of any matter relevant to the subject matter of the action is also gone. And finally, the phrase that discovery includes the existence, description, nature, custody, condition, and location of any documents or other tangible things, and the identity and location of persons who know of any discoverable matter is also removed from the rule. So, to the panel, what does this mean? What is it going to mean to practitioners and clients that proportionality, which, as the judge mentioned, has been part of the rules for a long time, is now in the scope of discovery? Bob, do you want to start with that?
I will. This I think, is an extraordinarily helpful change, especially for those of us that spend most of our life on the defense side of the V. You know, the United States adopted the philosophy of full pretrial disclosure in 1938 at a time when litigation files typically were a few pages or perhaps at most a few red wells. Now, as you all know, a case file can literally comprise millions of pages of documents. So we have this collision of the philosophy of full disclosure and the explosion of data sources and volumes. And the parts of the rule that have now been admitted or will be admitted on December 1st led to a lot of mischief. And basically, as a litigator who's toiled in these fields for 40 years, there was very little, if any, restraint on the scope of discovery requests. I'm a huge fan of this, and we're lucky to have Judge Grimm here. We were also lucky to have him and Dave Campbell as the two driving forces on the Rules Committee over the last 5 years at this critical time. And we owe them both and the committee a lot of thanks. But for this to make a difference, all of us who practice will have to use this rule. We're going to have to argue against discovery requests that are overbroad. We're going to have to push back. And especially, we're going to have to learn how to use the proportionality concept. It's an extremely important element of the scope of discovery. Obviously, it was in the rule as 26B2C3 for 20 years, but people really didn't use it. Now it's there, it's in front of our face, and we need to remind our clients, we need to remind our law firms, push back on discovery requests that exceed this, and only then will it make the difference that it's intended to make.
So Malini, Bob just said that it depends on how you use it. How is this going to be used? Is it going to be that you get a discovery request and you object on the basis of proportionality, and that's the discussion, or how is proportionally going to matter to discovery requests?
Thanks, Alex. And so I'll start first with a question to the audience, or a couple of them. How many of you have actually read the new rule before today? How many of you have read the committee notes? So, I mean, it really starts with that, that all of you have to familiarize yourself, to Bob's point, with the rule itself, and more importantly, with the committee notes, because they really tell you what drove these amendments. Because on the one hand, I mean, and I was interested in the notes, you know, the 1983 committee note cautioned, the court must apply the standards in an even-handed manner that will prevent use of discovery to wage a war of attrition or as a device to coerce a party, whether financially weak or affluent. That is as applicable today as it was in 1983. And so unless defense counsel because discovery does play such a big part of litigation, familiarize themselves with this rule, the committee notes, and think strategically about discovery, we're not going to get the benefit of the work of the committee and everyone who contributed, who testified, because we're not going to understand the value of this. And in answer to your question, Alex, I don't think it's completely reactive. I think that's actually would be foolish. And we play into the hands because, you know, I think a lot of plaintiffs' lawyers are going to say that this is not a meaningful change. And it makes me think, well, then why did you fight so hard against it? And so I think, you know, for me, and I testified before the committee, and I've been asking myself, you know, what is the value of the change? And I do think the movement of proportionality from B2-3 to B1 is significant in terms of emphasis. I think it's important in terms of ensuring a greater consistency within the judiciary, right? When they read these rules and see the emphasis on proportionality, how our decision makers view it and the factors. And so I think it provides greater clarity for judges in terms of the importance of weighing these 6 factors. So then and a lot of it remains to be seen. How are these 6 factors going to be weighed? And we have a role in how we tell that story. In fact, we have a very big role. So to me, it's really about being proactive. So, you know, what Alex's question in terms of being reactive, I always say the first time the judge hears about discovery and what we've done shouldn't be at the motion to compel stage. Because then we are completely on the defensive, right? We're justifying not producing something. And I think it's almost too late to explain everything we've done up to that point. I think we have to be much more proactively engaged and be telling the story because we do cooperate so greatly. We do produce so much. I mean, most of my litigation is asymmetrical, right? I'm producing the lion's share. I have litigations where before we've gotten anywhere close to the merits, and I'm not joking, I have 200 to 300 lawyers doing nothing but document review, right? Either through a managed review vendor or through a law firm. I mean, that is before we've come anywhere close to discussing a single question on the merits. So we've got to tell that story. You know, it's too late when we're doing it because someone's asking for something. And we're saying, no, we're not going to give you that, and hear everything we've given so far. So I think this is, and you know, I'm going to just go through, and these are things that were true before the rule change, but I think become even more true and important now. One is, you've got to engage the in-house lawyer. You've got to understand how your client manages its documents, right? What is its approach to discovery? What's its approach to preservation? How do they handle their legal holds? I don't know, and I still find this true today, as actively as I manage litigation and as actively as my team manages litigation. where I still have outside counsel who don't confer adequately with us. We push them on Rule 26F before the Rule 26 conference in terms of looking at discovery plans, in terms of looking at that preservation order. You know, and to in-house lawyers, understand what you're committing to. I mean, have you read that preservation order right down to the nth degree? Because it's the devil is in the details. And so that engagement is critical between client and outside lawyer. You really have to understand the processes. And in terms of then, because what you're trying to do is create the most defensible story and your discussion of what's relevant. And the problem is relevancy is so broad, right? And what I think ultimately these rules do for me is I don't feel like I have to take the most conservative approach to preservation, which is preserve everything, and I don't have to take the most conservative approach to production, which is to produce everything that could possibly be relevant, right? I think it's now, what I'm focused on is reasonableness and defensibility, and that means very early consideration of that. And consideration with those 6 factors in mind, and the emphasis of which factor is going to change over time and depending on the litigation.
So Judge Grimm, Malini quoted from the 1983 Advisory Committee notes. As you well know, the committee has amended the civil rules to address these discovery issues in 1983, 1993, 2000, and now in 2015. What is it about the current changes that you think are going to make a difference this time? What's different, and how should members of the audience here participate in making sure that the result is different this time?
Yeah, I think that one of the key concepts, and again, this goes back to the interrelationship between the 4 themes, is that I believe that when you question lawyers individually and in the groups and associations that they work together in, whether it's plaintiff's counsel or defense counsel, there is a belief that when the judge is actively engaged in the management of the discovery process and available to help resolve legitimate issues that come up, that the process works better, that you can achieve proportionality. You can talk about phasing, you can talk about focusing on the correct things, you can talk about what's the most important information at the most economic price point that you can get. When the judge is not available, when the judge is aloof or hostile, then you can't make progress, because if the person that you're negotiating with on the other side is not willing to compromise or try to find middle ground, then the only other way that you can move forward is to have it resolved, however that may be. What I think that it was recognized, and you can see this in the supporting materials to the standing committee and to the judicial conference, if you read the legislative history of these new rules, is that the committee recognized that just simply changing the rules again was an essential first step, but it could not be the only step. And it's going to be followed by educational programs. That's why I hope that there are many more educational programs like this throughout the country, at states, throughout the states, that with every bar group representing every aspect of the litigation process. I know that there is a subcommittee that has been formed containing members of the active members of the advisory committee and some alum, myself included. I chair it. That's been tasked with trying to get the word out for judicial education, for education of the bar. But part of what has to happen is that I did a survey as part of some research I was doing, and I had the privilege of being able to test the views of 68 magistrate judges and 42 district judges. That's 110 judges. That constitutes just about 10% of the entire federal judiciary. And 82% of the district judges polled, when they were asked which best describes their approach to discovery, and the first choice was, I actively manage the discovery in my cases from the beginning of the case, or I wait until there's a specific dispute to resolve before becoming involved. 82% chose that latter one. So what you're finding is that a lot of judges are reluctant because they don't understand that it is cheaper, faster, better, and to resolve it. So, for example, if you need to have the judge involved so that you can make those important decisions, and I think what Malini was saying is that you don't, when you're halfway down the schedule and you are in jeopardy of losing all of those dates that the judge set and messing up your calendar and the court calendar, that's not the time to become engaged in what discovery is. If you look at the changes to Rule 26F, when the lawyers meet and confer, there are new things that they're supposed to talk about, preservation, for example. And that's in 502, Rule 502 agreements. When you look at Rule 16, the judge is now being encouraged to actually have person-to-person conferences with the lawyers at the beginning of each case. Ideally face-to-face, but if not, by phone or by telecommunications or Skype or Instagram or whatever, Snapchat or whatever you can do to have as a back and forth that is real time with the lawyers to get these things done in the beginning. And if that involvement comes in, then the judge, using one very specific rule, the rule changed to explicitly encourage and authorize the use of pre-motion phone calls, so that you can't file a discovery motion unless there's first been a conference with the court. I use that in every case, and the requirement is you can't file a motion. You get a letter that's 3 pages long, no more. It sets out the problem. I set it in for a phone call within 5 to 7 days. I get them on the phone, and there's almost no discovery dispute that I can't resolve in a quick phone call. And what I tell judges, and what you can suggest to judges in the cases that you have, if you get in that reluctance, you get that. When I was in practice, I did construction cases was one of the areas of litigation. And when you would go before a judge, usually in the state court, because they were individually assigned cases, and you were ready for trial, and the judge would say, okay, folks, what kind of case do we have here? And we'd say, Your Honor, this is a construction case. And the judge would go, a construction case? And we get this look of just abject terror on their face. Oh, God, it's a construction case. And when you say you've got a discovery dispute and the judge goes, a discovery dispute, then you know that there's a reluctance. That's how you subtly figure out whether there's a reluctance on the part of the judge to get involved. What I tell judges is, which would you rather have? A 3-page letter explaining the problem and a 15-minute phone call to resolve it, or a motion with a 40-page memo and 70 exhibits, with an opposition with a 35-page memo and 20 exhibits, and a reply with 25 pages and the memo and 40 exhibits. There's a no-brainer on that to me. And by encouraging the judges to get active in the very beginning of the process and figuring out how that's supposed to go, what happens is that the judge has a partnership with the lawyers, helps to figure out what is going on, gets immediately the sense of what lawyers are bringing the right attitude to the table and which ones are not, and has an ability to manage the discovery process iteratively. Too long we've had the situation where discovery is give it all to me right now, and opposed by give you nothing if I can avoid it. And we have to move beyond that. But the best way is to get the court involved. And if you can do that and overcome that reluctance, and we're trying to have judicial education to help show the benefits of doing that, getting the word out to every judge in the United States. These new rules are there. We're preparing videos that will be broken down by subject so the judges can have those in CLEs. We hope to make those available to the public as well, so that these kinds of educational process will be there. But it's going to take a sustained effort, at least through the next year, to get people to be really involved with that by talking about how you can get all the stakeholders involved from the beginning. If you can do that, Alex, that's what will be different this time. Absent that, then 10 years from now, we'll be talking about the 2025 changes to the Federal Rules of Civil Procedure.
Right. So I'd like to ask our practitioners, liberal and even overbroad discovery is so much a part of our legal culture, and largely, I think, because of the misused phrase reasonably calculated, which is omitted from the new rule. What are you going to do after the rule changes take effect when you have an opposing counsel who doesn't think that that change means anything, and you're going before a judge who may not have read the rule or the comment to convince them that that something has changed, something important has changed in the rules, And I also, of course, would like to hear from the judge. Judge, how would you expect lawyers and parties to bring that to the attention of judges who may not be familiar with the new changes to the rules?
First of all, be conscious of the change and be sure that all of the people in your firm are conscious of the change. And secondly, use the notes. Malini pointed it out. The notes are a spectacular resource, more important perhaps in these changes than in prior changes. And there's a lot of good nuggets in those comments that you can use as advocates to restrain over broad discovery requests, and then have at it. That's what I'll do.
For me, it's approaching it with specificity. Don't wing it. I think, and I couldn't agree more with Judge Grimm in terms of the role of cooperation, because so much just through active discussion and negotiation with the other side of the V, you can achieve agreement on most things. And the other tool I've seen is actually one that Judge Hellerstein has the parties do, which is you actually, when you have a dispute, to do it in a joint letter. And what I've found, right, where you lay out the issue, then I'm most often a defendant, so and then the plaintiffs put their position, and then the defendants have to put their position in the same letter. And in the process of going back and forth, you actually end up resolving the vast majority of issues and are able to isolate it to the one thing. Now, it doesn't have to be the letter, and then I agree with you in terms of the conferences, and I find the best judges now, especially in the large litigations that I have, now routinely schedule those calls. And if you don't need it, you cancel it. But to have that, and what it forces is the parties, it's a formal mechanism to force the parties to prepare. And to me, and I really like discovery roadmaps. I think you can talk a great game, but when you have to write it down and defend it, you start to realize that some of the positions you're taking are not the most reasonable positions. And so I can't emphasize enough, whether you're going into court, whether, when you're drafting the plans, you really have to understand the case. You have to look at these factors. You have to map out, okay, what are the documents in all of these areas that I reasonably should be producing? Whose are they? Write down the names. And I think then you're going to be positioned to be able to argue with great credibility when the other side is asking for more than that, why that's unreasonable and disproportionate to what is appropriate in that particular case, and looking at each of those factors. But I think that kind of preparation is critical.
What I think would be a helpful technique, I think most judges would appreciate, a party coming to them and saying at the beginning of a case, Your Honor, as I'm sure you are aware, usually when I'm in a hearing and someone says, as Your Honor knows, the little thought bubble about their head is, I've got to find a subtle way of letting teaching this idiot something that they obviously don't know. Well, Your Honor well knows, and then that's when you say to someone with all due respect, and the thought bubble which is absolutely no respect whatsoever. But what I think is, that Winston Churchill, the author of many great phrases, is reputed to have said that tact is the ability to tell someone to go to hell in a way they can look forward to the trip. And so, good trial lawyers know how to behave with a measure of tact with the court. But I would certainly, if I had a lawyer say, Judge, there's this new technique that the new rules have put in about having pre-motion phone calls. And we'd like to see if we could convince the court that this was something that we could do in the event that we do have a dispute, rather than briefing it all up, if we could just have a joint letter, no more than 3 pages, 5 pages, and then have a phone call with the court to try to get some sense of direction as to where we can go, and then if the court believes that we need to brief it up, we can do that. It would be almost impossible in a situation like that not to have some benefit from that conference call. Because even if the judge says, I think you need to brief it, they're not going to be a cipher. They're going to give you some sort of a, well, wait a minute, I'm not sure about that, but if you want to brief it up, you've got a little guidance there as to sort of what the reaction is. So one way is to make the judge know that there are these techniques that you would like to take advantage of. The second thing is that I think that you need to think both strategically as well as tactically. You know that there is not going to be a case, whether you're a plaintiff's lawyer or a defense lawyer, where you get all the discovery you want and produce no discovery. There's no universe in which that's going to happen. So rather than engage in sort of that war of attrition that has produced problems that led to some of these new rules, and part of proportionality is if you're going in there saying, Judge, what they want is disproportionately great, you can't really have a credible position taking that. First of all, if you make a boilerplate objection, it's overbroad, it's burdensome, it's not proportional, it's not likely to identify relevant evidence. Then you're not going to get anywhere on that because that's boilerplate, and the advisory notes say very clearly that boilerplate objections are not appropriate objections. But rather, if you come forward, whether you're a plaintiff or a defense attorney, and you come forward and you say, Judge, we believe that we have done an analysis and we have no dispute that there's a universe of information that we know the plaintiff is entitled to here. So pick any kind of case that you're out there, you know there's certain types of information based on your experience that you're going to end up having to give up. And whether you give it up after they've had interrogatories and document production requests, or whether you identify what you think is what you believe to be proportional, and you come and say, we're prepared to give this up. We can do it informally. We can do it in response to certain targeted interrogatories or document production requests. We're not talking about waiting 30 days to file an answer and then stalling as much longer as we can after that. You can't do that after the new Rule 34 changes, by the way. And then producing it, we'll produce it right up front. But then we have done an analysis, we think that this is probably what, based on our experience, they're entitled to have. Now, we're not saying that they may not have a different view of that and that we might not be willing to agree to more, but they should have to be able to demonstrate, based upon what we have initially produced, that what is more, which is wanted more, is proportional given what's at need in this case. So we know, for example, that we're going to have to produce the safety reports. We're going to have to produce evidence of prior complaints about this product. We're going to have to produce this, that, and the other thing. Just like the plaintiff knows, they're going to have to produce the medical records, the employment records. They're going to have to produce this other information. When you go to a judge saying that this is information that we are willing to give up, and we can talk about a timeline where we do this on an expedited basis, but this is the center of it, and beyond that, there should have to be a greater showing of proportionality. It's a completely different dynamic that you're given to a judge than objectionable is burdensome, and you offer nothing in return. Then if the plaintiff comes back and says, whoa, Judge, I need it all right now, I can't take, then they look like they're the ones who's unreasonable. Similarly, it's the same thing if a plaintiff's counsel comes and says, we know that the plaintiff's got to be deposed, we've given them the medical records, but they want this, this, and this. Then a defense counsel who asks for much more than that is going to look like they're being disproportionate. So you have to have, I think, a smart game. You got to come knowing that you're not going to go into this fight without having some disclosure and discovery you have to give. So identify a universe that you are comfortable that you're going to have to give, and then the other things, try to reserve that and say, let's produce this first and then see where we are, and use what you get from this first production to have to justify perhaps to a higher standard, and perhaps under Rule 26C, where the cost allocation, perhaps we should then have a dialogue about who bears the expense in whole or in part. Completely different approach and a completely different reception that I think a judge would give to that, and that's whether it's done by the plaintiff or by the defendant.
With that mention of 26C, I'd like to mention and show that another change that's a part of the package of rules changes that it's going to occur on December 1st is a modification to 26C that expressly allows protective orders to include an allocation of expenses. Who's going to pay for discovery? The committee note to this change says that courts already have the power and that this is codification, if you will, of that power. So my question to the panel is, are judges going to use this more often because it's in the text of the rule now? And what does it mean to the proportionality test that we were just discussing? Bob, do you want to start with that?
Well, it's a great, as Judge Grimm told us, there are these four themes, and they interrelate extremely well and should be applied jointly when we're making arguments. But the allocation of expenses and proportionality is a perfect pairing, if you will. Yes, the courts have had this power, but I think it's a huge benefit that this phrase is now in the rule. It's an economist's truism that underpriced goods are overconsumed, and basically discovery in this world has been free to the other side, and so they can impose costs on their adversaries for nothing. I don't think we're going to see a user pay system anytime in my career, but there can be movement toward that. I hope that it exists. I hope that it happens. Now we have something express in the rules. And one of the comebacks to a plaintiff saying, oh, no, my requests are not disproportionate, is to bring up the allocation of costs. You all have had the same experience, I'm sure, that once the judge starts talking about someone wanting overbroad discovery to pay even an increment, not the whole cost, but even a share of it, the requests get more reasonable. And so we need to remember proportionality, allocation of expenses, and push back on these things. We on the defense side of the V, I mean, I have two enormous plaintiffs' cases as it happens, but most of my life has been on the defense side of the, we need to remember to push back and use these rules the way they were intended to change behaviors all over.
Judge Grimm, one of the things that you're well known for in this area is that you have been including a phrase about allocation of expenses in your regular scheduling order for some time. Could you share with the audience what you do and how that has worked in your court?
I just want to say a sort of preliminary point. The advisory notes on the change to 26C regarding allocation of costs is very important to read. What it does is it simply puts in a rule what the Oppenheimer case that the Supreme Court came out with in 1978. Oppenheimer is the case that stated the presumption that continues to exist. This rule doesn't change that. That the baseline, that the default is the producing party bear the cost of discovery. I think that you could probably rephrase that to say the producing party bears the cost of proportionate discovery, because that's a reminder that it's within the scope. However, in the very next sentence, the Supreme Court said, however, the trial court has the ability to address undue burdens and expenses through a protective order, and that's where the language came from. I have a standard discovery order I issue in all cases, and it contains in there sort of a phasing requirement that you focus on the facts that are relevant and not privileged, that are most important to try to prove the claims and defenses that have been pleaded. That is now the scope of discovery. The broader scope that deals with the subject matter has been eliminated, largely because no one could come up with a helpful dividing line between what is relevant to the claims and defenses as opposed to what's relevant to the subject matter, since the claims and defenses identify the subject matter. It was one of those definitions that was accurate but useless. So as a result of that, I'll say, and I limit the interrogatories to 15, document production requests to 15. I require affirmative production within 60 days of receiving the document production request. I limit deposition of fact witnesses to 4 hours each. I require cooperation. I have pre-motion conference call. I prohibit boilerplate objections, and I go over that in my Rule 16 telephone conference call in every civil case. I'd love to be able to give you some specific examples of what happens on that, because it's never come back to where the plaintiffs have come back and said, we want that second phase. I have never had a problem with it. The mere fact that you know that this dialogue can take place is a sort of a reality check. And the reason I think it happens is that, I hope anyway, that the lawyers know is that if they do have a problem with something, then they're going to reach out and have that phone call. And I want to talk to something that Malini said just a moment ago, which is so true. I can't tell you how many times I have on my calendar a discovery dispute phone conference that pops off the calendar within 48 hours of when I get there. When they actually start getting ready for what they're going to say, just the fact that you have someone who can break the tie available is there. So I think it needs to be part of the discussion, but it should be part of the discussion. If you start with cost shifting or cost allocation, I think you're going to lose most judges. If you start with, we recognize that there is a body of information that is proportional to the resolution of these disputes. The plaintiff and I may have differing views of where that is, but we all know that there's information. And we think that we should each identify what we believe is information that we're willing to give to the other side because we know it's proportional and it's going to be subject to the scope, and exchange that information and start with that. And then if we need to go beyond that, then, Your Honor, we'd like to have the ability to come back to you if we have some problems, but as part of that dialogue, we'd like to be able to have a discussion of cost allocation as the rules say. And it's shocking that when you start with that notion of you're going to come to the table, but no one's coming to the table with the expectation that one side or the other is going to prepare and serve the entire meal. If you're coming to the table, each of you is going to bring something to the menu, and you're an obligation to do that, then it's amazing how the attitude changes. And just getting people pushed beyond that sort of knee-jerk reaction. There is too much of what I call a tennis game mentality to discovery. You serve some discovery requests, and then you sit back and wait, and someone serves an answer back. And then you write a letter that serves some objections, and they write a letter back. And in between, you don't think of it. You've got to get beyond that incremental, I do this and then wait, and then come back to something later, to the notion of looking at it from the very beginning as a plan. It's exactly what you say, map it out. And you know that there's areas of stuff that you're going to have to give up. And if you identify that and talk about the most cost-effective way, each side, plaintiff and defendants, to do that, then the stuff that's on the side is the area within which, if someone wants additional discovery, it's logical and rational to talk about, now, who bears the cost. Think of it this way, and I can't claim any credit for this. Steve Gensler, who is a professor of law at the University of Oklahoma and was on the Rules Committee, has a very useful way of looking at the notion of discovery. And he says you're going to be in an archery contest. So when you're at an archery contest, what do you shoot for? You shoot for the bullseye. You don't shoot for the periphery and work your way in. You shoot for the bullseye and you work your way out. Think of what the bullseye discovery is that you got to have from them and that you know you're going to have to give to them. Start with that and figure out a way to put that forward. Even say, Judge, we don't need 60 days for document production requests and interrogatories. We will give this information up. If they will give us this information up, and then based upon that, let's talk about if there is anything more necessary. Part of that's going to be a deposition of the plaintiff. Part of that's going to be a 30B6 of the defendant. But identify what that is, and then center it around the bullseye. And then when someone wants beyond that, as a second phase, when someone's coming back for a second plate, that's the logical place to go to Rule 26C, regardless of whether it's the plaintiff or the defendant coming back.
And just to supplement what I said before, you know, we've lived in this era of full disclosure all of our lives, basically, and we've become accustomed to asking for everything and then fighting over the margins. What we've lost, and what I'm trying to return my own self to when I'm approaching a new case, what are the most important disputed facts? Don't, you know, what are the top 3, not the top 10? What are the top 3? And focus my attention on those things. I find that that has a clarifying effect on what I'm requesting, what I'm gathering from the client, and what I'm focusing on, because we can all boil the ocean till the end of time, but it doesn't really get the dispute resolved, which is why we're hired.
I've been nodding with what both gentlemen have been saying, but particularly with what Judge Grimm was just articulating, because I think, you know, this whole point of the active judicial case management is so critical. And in order to get any benefit of 26C, right? I mean, if you're lucky enough to get Judge Grimm, you know you have a judge who is right from, the case management orders that he issues in terms of he is going to be actively engaged. I think the critical thing is, and he used the word strategy and be strategic and tactical in how you approach this. And part of that is if you have a district court judge who isn't engaged, you have to figure out how to draw them in. And you can't keep them removed and really unaware of what's happening between the parties with respect to discovery during that entire period, whether it's months or in some cases, can drag out even longer. It shouldn't. That you've got to figure out how do you, and he talked about actually actively requesting those conferences, but more importantly, I hope people were listening to how he was talking about communication, right? And how we communicate with the court. And it was really an openness, but you can be that open if you're being reasonable. I mean, I emphasize with all my lawyers about being reasonable and credible, and not doing the knee-jerk defense reaction of, well, they asked for it, so I'm not going to get it. I mean, you really have to, because at the end of the day, our credibility is so critical. If you've approached it this way, and I am waiting to see what happens with the cost allocation. I mean, I'm glad the language is in there and that it's express, but at the same time, the committee is very clear that they don't intend this to become common practice. So what does that mean? When do you ask? I think Bob's and the judge have given some ideas that it's really when it is becoming so particularly burdensome and disproportionate. And then I liked Bob's suggestion of being incremental in the request, but that's going to be case by case. But I do think we've got to be strategic both in our individual matters, but also thinking about this as a bar, about how we go and make this work, because those first requests, and if there are decisions written, are hopefully ones that are granted and give good language for when it's appropriate to actually shift those costs.
I want to switch now to another major theme that Judge Grimm mentioned about the rules, and that is the new rule about failure to preserve electronically stored information. Unlike the other rule amendments, this one is a brand new rule, and it is 37E. It deals with the failure to preserve ESI, and the rule states that if electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost, and that's one of the keys, because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery, then the court has the following powers. First, if there's a finding of prejudice to another party from the loss of the information, the court may order measures no greater than necessary to cure the prejudice. Or, if there is a finding that the party who lost the information acted with the intent to deprive another party of the information's use in that litigation, then the court may presume the lost information was unfavorable to that party, instruct the jury that it may or must presume the information was unfavorable to the party, or dismiss the action or enter a default judgment. You may note, I think most practitioners think of this topic as sanctions. The word sanctions does not appear in the rule, and so I'll start with you, Judge Grimm, this, by the way, this was the discovery subcommittee that Judge Grimm was chair of that developed this rule. Where is the word sanctions? Why is that not there? And does this reflect a different approach than what we're used to in that context?
I think that this area, this rule was one of the most difficult for the committee to try and come to grips with, because we had some we had a deal in the situation where it actually implicated the Rules Enabling Act. You cannot create or abrogate an evidentiary privilege through ordinary rulemaking, so you have to be careful. The duty to preserve is not a rule-based duty. It's a common law obligation that we inherited through the common law. It traces its way back to, ancient Roman law and as adopted by the Great Britain. And the Latin phrase was omnia praesumuntur in ordium spoliatoris, all things that are presumed against one who loses evidence. It didn't create a problem for the first 225 years of our existence because it was dealing with, if you were suing over, injury to a certain item or land and it was lost or wasn't there, then it was central to the litigation and everyone could see why it was important and what the prejudice was. And if someone was at fault for losing it, it made sense to not give them a reward for having done so. Now we get to the point of electronic evidence, which can be lost, overwritten, restored on devices that there's no longer software to drive them. And so you have, and there's so much more of it. This is when it became a problem. So the beginning is the rule deals only with ESI, because if it's an airbag case where the airbag has been lost or destroyed, the existing rules work pretty well. But what happens with ESI? If you look throughout, and to address your question, Alex, about sanctions, when we were talking about this in the committee, we said the rules are full of sticks. You can be sanctioned for this and sanctioned for that, and attorney's fees and costs, and all of these things can happen, powers of contempt. But there are very few carrots that the rules offer. We wanted to have a carrot approach before the stick. And if you go back to the very beginning of the rule, the very first thing we want to do is, what's the carrot that we want to reward? We want to reward someone with a carrot. So what's fundamentally what we want to reward? Reasonable behavior. Reasonableness, by definition, includes proportionality. So at the very beginning, you have to have a failure to preserve electronically stored information that should have been preserved. Now, the common law trigger, when you reasonably anticipate litigation, is a very simple, easy, uniform rule that everyone can understand. Its application can be difficult in cases individually, but the rule is a crystal clear rule that anyone can understand. So we did not change the trigger, but should have been preserved in anticipation or conduct of litigation is lost because a party failed to take reasonable steps. If you can demonstrate, and this is what I think Malini was talking about, is having an approach to your litigation preservation that shows that you have anticipated future cases and developed a program and documented it to show that it's reasonable. If reasonable conduct is there, even if it was lost and it was vital, the rule stops right there. You don't go any farther. There is no consequence. If a party is not responsible for the loss of the ESI because of unreasonable behavior, that's it, end of game. So the carrot is, let's encourage people to think these things through in advance and develop reasonable programs. Document it so that if there's a dispute, they can come in there and show it. Also, it gives them a guard against perfect hindsight that may occur by trying to evaluate a decision 2 years ago when something came up that could not reasonably have been foreseen. All right, so the first thing is that we've now got someone who has behaved unreasonably and they've lost it. What's the first thing we should do? Do we sanction them? Do we hit them with a stick? No. What is it that we want to look to first? Can we restore or replace it through ordinary discovery? Stop there. Do not go to sanctions. Talk about getting the information. Well, ESI, one of the things that makes it so challenging is there's no such thing as a single email anymore. It's a single email sent to 1,000 of your best friends. That's then been sent to 1,000 of their best friends. It's been posted on Facebook. That's been put on, Instagram. And so now I may have lost it, but we can get it from another source. Let's go get it from that source. Okay, we can restore it, or we can replace it. Can we replace it with the exact information or maybe a near duplicate? So it focuses you on trying to make sure that you get the benefit of what was lost or destroyed only if there was unreasonable behavior. And then only if you cannot restore or replace it through ordinary discovery do you drop down to subparagraph 1, which is requires a finding of prejudice and then the judge can initiate curative measures no greater than necessary. Do not go beyond what is necessary to do what? To sanction, to punish, to deter? No, to cure the problem. The rule is specifically broad in recognizing the discretion of the trial judge to figure out what they do as a curative measure. They cannot impose any of the three very significant measures that Rule 37E2 comes in with. The adverse inference presumption, default judgment, or striking pleadings or cases. Those three things cannot be done only, even on a finding of prejudice, unless you have the enhanced intent that we'll talk about in just a second. So what might be an example of curative measures if you can't restore or replace and there has been unreasonable conduct that resulted in the loss? Well, maybe you're going to look at backup tapes. Maybe you're going to look at information that you would otherwise, under Rule 26B2B, have said is not reasonably accessible because of undue burden or cost. There may be some allocation of cost to the party that lost it to have to pay to have the forensic examiner go in there and recreate what was done and to bring it back. So it may be that the judge is going to say, well, we're going to allow the jury evidence to be introduced that this person did lose it, and the jury can weigh what evidence came in so that if one party couldn't get evidence that it needed, the jury understands that it couldn't prove that part of its case because it couldn't get it, and they can consider that when they're evaluating the weight. That's not an adverse inference instruction. It's just the ordinary weight that a jury gives to the evidence, and it's sort of like the lost evidence presumptions that can come. Those are just ordinary inferences that can be drawn. And then the final step, where we haven't even used sanctions in the language there, Alex, is at the very end, when is it that courts should be able to take the steps that are sort of the potentially case-ending consequences, the ones that everybody dreads? And this is where we went back and forth and back and forth. And as you know, the common law that is now being displaced by this is that some jurisdictions, some circuits said it was mere negligence, some said gross negligence would survive, others said no, it had to be bad faith. First of all, we wanted to get away from concepts of using words that had multiple meanings and in different contexts. So you'll see that there's the intent defines the conduct that everybody agrees is impermissible and should bear consequences. If you engaged in unreasonable conduct that resulted in the loss of ESI because you intended to deprive an adversary of its use at trial, then that conduct is conduct which is significantly culpable, that consequences that are serious should flow from it. Now note that under 37E2, there is no finding of prejudice that's required. Some folks have said, oh my God, this is ridiculous. The judges are going to kill us because there was an intent to deprive. But think about it. If you find that someone, one, behaved unreasonably, and secondly, intended to deprive, then the prejudice, as the advisory notes say, is inferred from the intent to deprive. If I get rid of all the emails without reading them, not knowing whether they're helpful or hurtful, they're gone now. I may not be able to show prejudice by the loss of those emails, but the very fact that I thought they were bad enough to get rid of without reading them or having you read them is enough for you to be able to take some of these consequences. So you can presume that the information was lost or unfavorable. A judge can do that at motions practice or in a bench trial. Instruct the jury that it may or must presume the information was unfavorable. That's your adverse inference instruction. Or dismiss the action or enter a default judgment. That is limited to only those circumstances where you've had unreasonable behavior, information is lost, and you have that intent. And from that intent, you can infer that it was prejudicial.
Judge, I'm curious, what you've just articulated is different from the case law in some jurisdictions. What effect is this rule going to have in the jurisdictions where today a negligence standard is used to determine whether the information can be presumed to be unfavorable? That's
a great question, Alex. In those jurisdictions that have that, that negligence standard would still apply to non-ESI evidence because the rule only applies to ESI evidence, but any circuit or district authority that is inconsistent with the rule change will be superseded by it. because this is an act of Congress that will approve it and have it come in. So that's the law of the land. So if there's, there is a case, the residential funding case mentioned in the advisory notes. This rule specifically rejects the residential funding notion that negligence or gross negligence can be a basis of these very serious sanctions. Now, why is that? People say, well, why are you doing that? You're trying to encourage spoliation. And the answer is absolutely not. Remember what you're talking about with an adverse inference instruction. You can infer that the information must have been harmful to the person who didn't preserve it. What is it that requires that harmful? If I am completely sloppy, I have one of those offices where I can't find anything, and there's an important piece of information there, and I don't know which pile I put it in, and somehow it got thrown away by mistake, you can't infer from that that I intended to prevent someone else from having the use to it. I'm a mess. I have no idea where things are. The inference doesn't apply. But if I say, get rid of that stack right now, there's going to be trouble, and I want that gone, and no one ever saw that, it never existed. From that level of culpability and intent to deprive, the inference that it was unfavorable to me naturally flows. And we went back to the roots of the common law in order to get it. The word sanctions were not used because, quite frankly, the spoliation common law doctrine, Alex, and I know that Bob and I will agree with this, was being used to hijack the substantive issues in the case, put them on hold, and go right after looking for, starting with punishment, right, before you ever got to the notion of duty and breach, culpability and relevance and prejudice. So what the committee thought was, let's get rid of words that have their own emotional connotation to them that divert us from what we should be looking at. And that's why we don't use the phrase bad faith, and that's why it's structured the way it is. And give a reward for reasonableness, restore or replace initially first, and if you do that, end of story. Only when there's prejudice can you get these broader curative measures, and none of these case-ending, light death, as the end of the world as we know it, can be imposed unless there's that intent. And based upon that, we thought that we have come up with a formula that if applied, and you have to do it step by step, that if applied that way would be helpful and a basis to be able to achieve real improvement.
Unfortunately, we're out of time. I want to conclude with one final question to tie a couple of these themes and rules together. The new Rule 37E speaks of information that should have been preserved in the anticipation or conduct of litigation. Earlier, we were talking about the proportionality test that's being imported into 26B1. What, if any, is the relationship between the proportionality test and the scope of discovery and the language of this rule about information that should have been preserved?
Alex, that's the most important concluding thought because we hadn't touched on it. It's expressed in the notes that the proportionality principle also applies to the preservation decisions that you make.
It's even more than that. It also applies to curative measures.
How is that?
Because the court needs to consider proportionality in deciding what curative measures should be ordered. So that remember, you've got scope of discovery, which builds in proportionality. The duty to preserve, when you think about it, this all ties in. That's why we talk about the four themes, and you need to think about these four themes as each aspect of it. You only have a duty to preserve information that may be relevant to the resolution of the case. What is relevant to the resolution of the case? The information which is relevant and not privileged to the claims and defenses. That's the scope of discovery. If proportionality goes into that, then proportionality is not everything plus a pony. You have to take a look at what is involved with it. It's very, very granular, and it goes back to the claims and defenses. What should a person reasonably have had to preserve in this case, given these claims and defenses? That talks about what the scope of discovery is. It talks about proportionality. It talks about whether you were reasonable to preserve it, and what is a reasonable curative measure to impose on someone who lost it. Because if you lost something that's beyond the scope of what you should have reasonably preserved it because it was disproportionately expensive, then that is something that the rules could allow to be brought to the table, and it should not result in you should never ignore the concept of proportionality that's throughout the application of what that rule is. It's embedded in the core concepts that make up the rule.
Alex, if I can have 1 minute, because I do want to emphasize a couple of things. Critical, and I think we've all been behaving this way, but it's clear that it's in anticipation of litigation. So you can't just wait until that lawsuit is filed, right, in terms of preservation obligations. And I wanted to point that out. The second is, and I think a lot of defendants can be guilty of this, which is that when someone else gets that sanctions order, you assume the other. You think, that's not me, we're so much better than that. My reaction is always, there but for the grace of God go I, because I think there are very few truly bad actors. It's often just because of the volume of information and data that we all store today that it's inadvertence that results in it. And so, and what I encourage everyone is not to put their head in the sand on this, and to really create that defensibility story. Whether you have a formal standard operating procedure, if you want to get a third party to come in and actually do an audit, so you've got that and you can show the court, this is the steps and measures I've taken to make sure I am taking the most defensible and reasonable position. This is how far I have gone. And I would also say bring in experts. I mean, people like, I don't mean experts in the formal sense. I mean, there is people like Bob, right, who are viewed by the courts and who are viewed generally as experts in e-discovery. Consult with them. I mean, we had a question on a very, very narrow issue about what was the most reasonable position to take. We looked at all of the case law, very nuanced area, and I looked at the case. I happened to know the special master, and I told my lawyer, go call the special master. See if there's something distinguishing about that. Let's go dig in. I'm not saying you have to do that in every instance, but you have to create that story and you have to think about it ahead of time.
Any other final thoughts? We'll wrap it up there. Thank you very much.
Thank you.
I want to thank our panelists. We had many, many questions that came in, and so I know that people will have an opportunity to talk to them in the break. We are going to cut our break a little bit short and try to be back here about 10:32 or so, just so we can get moving with the next session. And so with that, thank you very much.